Okay, we're going to start this webinar. I'd like to welcome all of our attendees. I saw the list of registrants earlier today, and it looks like we have quite a diverse group of people joining. So from everything from attorneys to business folks, including people from large multinational companies to startups. So we're looking forward to providing all of you with hopefully some very interesting information. This webinar is part of a series of webinars that our firm is hosting. And if you enjoy this one, I hope you consider also joining one of the upcoming ones that we will be advertising on social media and whatnot. Just a little bit about our firm. Dilworth IP is an IP boutique founded by Mike Dilworth. We offer a full range of intellectual property services, clearly with a focus on patents. We perform everything from patent preparation to prosecution to opinion work to strategy. We cover just about every aspect of IP law. In addition to IP, we also have considerable capabilities in kind of adjacent fields such as commercial contracts as well as marketing and advertising review. A little bit about myself. I joined Dilworth IP as a partner about 1.5 years ago. Prior to joining, I was in-house counsel for Energizer's personal care goods business, which about 4 or 5 years ago renamed itself Edgewell Personal Care, where I helped support some pretty famous brands like Schick Wilkinson Sword, Playtex, Hawaiian Tropic, Banana Boat, and Diaper Genies, just to name a few. I held the position of Deputy General Counsel, where I headed up the patent department, including global litigation, as well as the commercial contracts department. In kind of a hair club for men type of way, I not only am I a member, but I used to be a client. So when I was Deputy General Counsel, and it was an in-house attorney, I used Dilworth IP for some of our legal services. So I knew the firm well before joining it. My areas of expertise are similar to my in-house days, where I advise clients on intellectual property strategy, preparation and prosecution matters, as well as render opinions and work on litigation. I also handle a number of commercial contract matters for clients. I work with all types of clients, from startups to multinational corporations. And I have a degree in mechanical engineering from Villanova University, and I received my law degree from the University of Connecticut. And I'm admitted to a practice in Connecticut, the USPTO, as well as in the federal courts here in Connecticut, the Federal Circuit, and the US Supreme Court. So today, our panel is going to be talking about kind of managing a patent portfolio in the current climate. With COVID-19 affecting just about everything we do, it's also going to affect our budgets, how we do business, and even where we do business. So when we were considering what topics to cover in this, we tried to choose 3 areas that were likely to be affected by changes as a result of this current pandemic or a future crisis, or long-term solutions that beyond this may also help run a more lean, efficient patent department. With that, we're going to be talking about efficient prosecution of patents, maximizing the value of your patent portfolio, and also some tax-related matters, including corporate structures and tax treatment of patent-related activities. So we've assembled this esteemed panel that you can see on our screen here. The one image that you see I'm not sure where it will appear in your array of images, but Doug Wendt, that you'll see that name. He's going to be in the background. He's an outside consultant for our firm, and he's helping us run all the logistics. So he won't be providing any commentary today, but he will be helping us out here behind the scenes. So the first panelist I'd like to introduce is Annalisa Gallo. Annalisa is like me, a fellow Villanovan, and is currently the Associate General Counsel and Head of Intellectual Property at LIXIL Americas. And I'm going to turn it over to Annalisa to introduce herself a bit.
Hello. As you mentioned, I work for LIXIL. LIXIL is a sanitary company. We support GrowAway and American Standard products, so toilets and showers and faucets and all that type of thing. I've worked here for 4 years, built a patent department or an IP department. I support trademarks, copyrights, and patents, and we do everything contentious matters, prosecution, all that. Prior to coming here, I worked at BASF. I have a chemical engineering degree. So I worked in the chemical area for a bit, supported a lot of global business units there for also about 4 years. And then prior to that, I was in a law firm and primarily did patent prosecution and really focused more in the patent area.
Great, thank you very much.
Mm-hmm.
The next panelist I'd like to introduce is Daniel Gottfried. Dan is the chair of Dave Pitney's Tax and International Transactions Group. Dave Pitney is, Dan works out of the Hartford, Connecticut office here, and I'll let Dan tell you a little about himself.
Absolutely. Thanks, Tim, for having me and everyone for joining. I'm Dan Gottfried. As Tim said, I'm a partner at Dave Pitney. I'm a tax lawyer by training. I spend most of my time helping clients with international business structures and transactions, including lots of transactions involving intellectual property assets. I should also just mention for today's audience, I created and taught a law school course for a number of years on the taxation of intellectual property.
Interesting. Thanks, Dan.
Thanks.
And next, I'd like to turn to Cary Levitt. Cary is an intellectual property consultant focused on providing strategic advice to IP owners. Two tidbits about Cary before I turn it over to him is Cary is the very first 3-generation of patent attorney family that I've ever heard of. So both his father and his son are patent attorneys. And also, I think I've only heard of 3 Carys ever in my life that spell it C-A-R-Y. Cary Grant, now Cary Levitt, and my father is also Cary. So it's a small world for me. So Cary, happy to introduce you to the.
It's nice to hear that. I'm in good company with my namesakes, but I wanted to thank you, Tim and Michael Dilworth and the Dilworth firm. Thanks for the opportunity to participate on this panel, which is great, and it's nice to see a lot of familiar names among the participants. So hello to everybody. And Tim already mentioned the family heritage, which is really exciting. My father retired as the chief patent counsel of Merck. I've got a son now who's in the practice and is actually looking for a job. So I'll be soliciting all of your support and help in that regard. But he's 1 year out and had been practicing as a patent lawyer. For me, I've been practicing law for 35 years and mostly in in-house roles. And like Tim, I've had varied roles and had the opportunity to be general counsel of a couple of companies and chief IP counsel of a global industrial company, and more recently, the chief operating officer of one of the intellectual property service providers. And the one thing I can tell you is that being part of the profession and with the family heritage, IP is cool. So I'm always excited to be able to discuss, fun, sophisticated topics and participate on panels like this. So thanks for the opportunity.
Excellent. Thanks for joining us. And last but not least, I've got Ian Lodovice. Now, Ian and I have known each other for many years. Ian is active in the IP bar here in Connecticut. We were both past presidents of the Connecticut IP Lawyers Association, and Ian and I both are the co-representatives from Connecticut for another conference, the Joint Patent Practitioners Conference that's held in Times Square every year. So Ian's a familiar face to me, but I'll let him introduce himself to all of you.
Thanks, Tim, and thanks everyone at Dilworth for hosting this panel. I'm looking forward to the discussion. My name, as Tim mentioned, Ian Lodovice. I'm an assistant general counsel at Biogen, where my practice focuses on intellectual property. Biogen is a company that focuses on discovering, developing, and marketing products that treat neurologic disorders and other severe diseases. My practice focuses on large molecule and small molecule pharmaceuticals, both the sort of composition of matter as well as method of treatments, dosings, formulations. And that's it, I think. Go ahead.
Excellent. Well, we're glad to have all of you here. And now that everybody's met the panel, I think we should move on to the topics. So the first one we're going to cover today is efficient prosecution of patent applications. So the primary reason why I wanted to include this topic in the webinar is because this portion of a legal department budget is often a huge proportion. And when a crisis like the one we're dealing with right now occurs, and budgets are often constrained, this one finds itself in the spotlight fairly frequently. That places a heavy burden on legal departments to balance maximizing their IP while attempting to spend less. And while I'm sure most attorneys are always trying to do that, sometimes the outer forces are pushing those budgets further down. So in many cases, I've heard anecdotally that a lot of people just simply delay everything. You know, if you don't file anything or you don't respond to any outstanding office actions, you don't have any expenses. And while in the short term that often receives a lot of praise from business leaders, it really doesn't address the problem. It just pushes it further down the road. And often while budgets or expenses will go down immediately, you're just asking them to double or triple down the road when things actually come due. So I'm wondering, you know, I'm hoping the panel can provide some insights onto the best way or advice for people to handle a situation like this. And you know, I'll throw this out to Ian and Annalisa. What advice would you give to business leaders or legal departments out there that might find themselves in a position where budgets are constrained? How would you recommend, in here sticking to topic one, focusing on patent preparation and prosecution, how would you recommend that they maximize IP protection while attempting to reduce or minimize costs?
So I'll start and then Ian can add. I think one key thing at this point is to make sure you clearly understand what's important in your patent portfolio and your IP portfolio, to not only you know, make sure you really understand the roadmap, understand what the short-term, long-term, you know, products, where they're going, so that you can really value your patents and focus the money more on that. And ones that aren't as valuable or ones that are end of life, you can start to remove those and, you know, kind of refocus the amount of money that you have, I guess the pot of money that you have.
Right. And I always think that those decisions require a close discussion with your business and R&D colleagues to understand how COVID-19 or other budget tightening situations affect their business, and how will their research and commercial strategy change in the near term and the long term. It's sort of, you want to make sure that the portfolio that you have coming out of the tight time reflects the business goals that were established. You don't want to cut too much to be responsive to just budget cutting. You want to understand what the business strategy is. And I think, again, as Tim mentioned, there's often this push to sort of delay filing and prosecution strategy, but ultimately that just delays your costs for 3 or 6 months or potentially a year, and then you have this large cost. It's may have delayed your immediate budget, and it can cause some problems with your prosecution strategy, delaying data generation or delaying conversations with your inventors and R&D team. So it's not always recommended. I think we want to align with the business strategy going forward and not merely a cost-cutting strategy.
So as a quick follow-up to that, I think I know as an in-house attorney, I was in numerous situations where all of a sudden a budget would be constrained, or something happened with the business, or like in 2008, which was we had some more macroeconomic things happening. Once you're in a situation like that, it's often hard to see the forest for the trees. And what advice would you give to people in preparation for this? Should we be doing kind of crisis planning on a regular basis, not just reacting once a crisis happens?
Right. I can take that. One piece of advice I'd have is, while you're working with your R&D and business colleagues before an event like this happens, identify the key IP and essentially review your portfolio to understand for yourself and for your business colleagues, what are the priority patent filings, what are the less important ones, what are sort of essentially develop a ranking for IP. What is the IP that essentially covers your products, which are the nice ones and which are the ones that you can sort of maybe be more flexible in maintaining in a tough budget time like this. And it goes to this ongoing conversation with your colleagues about the substance and the strategy beyond your IP portfolio.
Yeah, I think also same thing with that is having your patent committee review meetings, having those every so often so you can review what's coming up, making sure you have the right people. That's the key, is to have the right people in the room. Obviously, if it's all R&D and inventors, everything's important. At least in my company, everything needs, so it's to make sure you have the business perspective. But then you also have to realize sometimes with business, sometimes it's short-sighted too. So you need to kind of find that balance. Also, which helps with the ranking and categorizing, is have a clean out every so often. Everyone's afraid to get rid of IP, but just have a big, every 2 years or whatever, a big portfolio review and just go through all of it, because, people change and things change, and all of a sudden something that was a hot topic that no one informed you, all of a sudden they've kind of made a change. So it's good to clean out, and that helps you prepare for times like this.
To follow up on that, you made a comment about sometimes business strategy can be short-term, reacting to these budget cuts and the immediate situation. Where I work in the pharmaceutical industry, where our product life cycle is generally 10 to 20 years plus. And if we're thinking about protecting the IP for pipeline products, not necessarily commercialized ones, we want to educate the business that while this is an immediate thing, in 10 years, our practice or our marketing strategy will likely be in these jurisdictions that would be easy to cut today or easy to cut back, but it's a long-term strategy. And depending on the industry you're in or the product portfolio and the product life cycle, I think that's an important part of the discussion with your business colleagues.
Yeah, and a good point there also, just a real quick thing, is also the countries, like you were mentioning, regions or areas to file. It's good when you're doing the ranking to decide, okay, the critical stuff, where do we need to file minimum? I mean, where you want to file, and then stuff that's not as important, maybe cut back on some of those countries. But in times of crisis like now, you can really go through and say, okay, do we really need all these countries? Maybe we just really want to focus on where we sell or where we're going to produce it or things like that. So.
Yeah, I think that's a really important point, that maybe, in some cases you wouldn't drop entire patent families. You might just drop a portion of a couple patent families in less ideal jurisdictions or less important jurisdictions, as opposed to just saying, okay, this family's gone, that family's gone, and cutting them completely.
Yeah.
I like the discussion about partnering with the business and marketing teams to understand, directionally where the business is going, especially globally, focusing on where you want to file or maintain patents. And I know we should all think back about what maybe 10 years ago or more, when none of us were filing patent applications in China. And now, of course, all of us are filing significant numbers of patent applications in China. And I thought about that, and it made perfect sense. And then I went to one of the marketing managers and I said, what's next? What's the next big market that our products may be prominent in, or we may be manufacturing, or competitors may be active in? Surprisingly, at the time, their answer to me was Indonesia. I'm not sure I believe it now, but so we actually started filing some patent applications in Indonesia to try to address that anticipated market direction.
And to follow up on the Cary, we've all had that conversation of why don't we have patents in China right now, right? Because 10 years ago it was not part of it. So I use it as part of the discussion with my colleagues now, that it's a long-term strategy, and while it's easy to be reactive, often it's better to think strategically about where the company and where IP protection would be most important 5 years, 10 years down the road.
And sometimes, I mean, when they want to blanket the world, you also have to kind of pull back and say, okay, are we going to really go after it there? I mean, you want to have, protection. You want to keep people away from developing something in that country. But sometimes when we start to get into all these teeny countries, the ability to actually go after and enforce is very difficult. So, you have to also kind of weigh those sometimes when they think they came out with this awesome product,
Right. And yeah, I know we use patents as a deterrent in many cases, but in times like this, is how much value is that bringing, and you kind of have to take that into consideration. Would I ever actually enforce this patent in this jurisdiction, or is it a nice to have? And I think that's an important thing to to include in kind of that document that you were talking about earlier, of that roadmap of categorizing, not just kind of almost in a two-dimensional fashion of important to least important, but also where is most important to least important on top of that.
Yeah.
Yep, and that's a fine line, because if you start walking down the path of, well, are you really going to enforce it? Then that becomes, I've had so many discussions, right? When they're like, why aren't we enforcing patent? Why do we need a patent if we're not going to go after everyone? So you got to be really careful of who you mention that.
Yeah.
Excellent. Well, go ahead, Ian. I'm sorry.
As this conversation evolves, it's sort of circling back to the point of not making a recommendation to delay costs. Like, it's this opportunity to focus on what is the value of your portfolio, what should you be maintaining, where should you be. It's not for those key patents, you should continue to prosecute them as efficiently and as aggressively as you always have. That shouldn't change. It's this outside, what's the real value here?
Excellent. And so I guess, kind of moving along, so we're talking about kind of that's in the active prosecution phase, or, where you're going to continue to seek protection. Would you change anything in your filing strategies now? Again, I think the knee jerk is often to just delay, which is again, not the best strategy in many cases, but what would you recommend to somebody who's has a budget constraint but also has invention disclosures rolling in? What would you recommend?
So we've done people file provisionals. That's great, right? Because it's a cost savings in some ways. You get your stake in the ground and you're not spending a lot. We have had portfolio reviews of patents that we've reviewed, and we realized, we haven't really developed too much. They're not really like super important, but they might be something. And so instead of actually going into a non-provisional or PCT, we've actually just we filed a new provisional. And obviously there's risks, right? Because we lost that year, but sometimes that's kind of the way that we've decided to go, instead of jumping in too early without everything and, you know, and then start spending money. The other things that we've done recently is, you know, a lot of times we used to file US and PCT, but now we just go right to PCT. That also pushes that off, and we hope, you know, we're in a better situation and, you know, a certain amount of time before we go to national stage filing.
Yeah. Yeah, and I think with that, the provisional filing where you may, under these circumstances, not convert to a PCT or a US application, you may lose a year, but you potentially gain a year in term if you're comfortable with the art that's developed or what you're aware of. It's not always, if the product or the program is not advanced, it can often be useful in the long term. You know? And I think to follow up on your point, and I think the using the sort of the PCT route just to delay those initial filing costs, do provisional PCT, and then wait to the extent possible to go national rather than filing directly in the US. You know.
Excellent. Sorry, please.
I was going to say, one thing, it might sound counterintuitive, but using effective examiner interview practice during these times to have sort of, you spend a little time with, in our case, outside counsel, developing a strategy, doing the interview, and hopefully advancing these cases quicker rather than having a written response and then another response from the office action. You're using it to condense prosecution essentially as a cost-saving measure. I mean, it might not show up in 3 months, but over the year period, you can feel the effects.
Yeah. I totally agree. I think interviews are extremely important. I think people are using them now more than they were in the past, but I think that it helps streamline prosecution. A lot of it is just purely understanding what they're saying. You know, sometimes you can argue back and forth and you guys are just heading head on head because you're not grasping what the real issues are. So I think, you know, interviews have definitely would help save money and make it, you know, efficient prosecution.
Yeah, I can even tack a little bit onto that as well. As you know, I'm a huge fan of interviews. In fact, you know, there's some benefit in certain circumstances where having 2 interviews with the examiner, where you have an interview, you know, to kind of feel out the examiner's position. Then you can actually put in a response to an office action. But then if you do it in an amount of time with time left on your term, you can actually then have a follow-up interview with the examiner after he or she has read your response, and then potentially file a supplemental response that you know could potentially dispose of the case in a single touch, as opposed to just blindly filing a response and then, you know, hoping the examiner buys your argument. And you only get so many touches, and when you're trying to save money, you really want to reduce the number of touches so that you drive down costs on a per case basis, as opposed to, you know, really a per month basis.
You know, one thing I would add, it's not necessarily sort of cost-cutting measures, but we're in this new world of interviews and all these communications in a different medium with a web medium. And so it's going into an interview, I think in some sense we still prepare the same way. But one part of my practice has been preparing sort of a condensed version of that interview, because we often have technical issues going into an examiner interview or any sort where you lose 5 or 10 minutes as people join or there's some technical issue. So I think of the sort of our full interview, but then also, well, if we had these glitches, let's make sure we have sort of our condensed strategy for this examiner interview call.
A little quick thing, and I know this is kind of coming off of this a little bit, just another little tidbit is foreign filing. If you can really pair up with a great outside foreign associate, it's very helpful for them to, give their input on how to respond to things or what they think would be successful. Because I think just pumping out some of your same arguments from the US, or you receive an office action from them and you're creating it, they sometimes know the ins and outs. And I think that also will save some money and time for you. Because and it came up because like for example, China, you really don't get a lot of bites of the apple. So it's like really knowing that you want to really streamline that.
All right. And before we move on to the next one, any other advice on ways in which you can maximize IP protection while seeking to reduce or minimize costs in this kind of preparation prosecution phase? Otherwise, I think I'm going to just move us along to topic number 2, which is maximizing the value of your patent portfolio. And for the second topic today, we wanted to discuss how to handle managing the patent portfolio of your existing patents. So we just talked about the ones that you're going to prepare or are in the process of becoming patents. Now let's talk about the ones that you already have and hopefully are keeping the competitors at bay, but that you're paying most likely an enormous amount of money to keep these cases alive in the form of annuity fees. In some cases, this could be millions or tens of millions of dollars, which again puts a huge spotlight on this expense when times get tough. The knee-jerk reaction again is often to just cut. And while this is a successful immediate reaction, simply cutting these cases to save those immediate dollars could lead to dropping IP that has value. And a lot of people really, after you make a short-term decision, you come to regret it later on. So in order, I think we're gonna hand this over to Cary, who's prepared a kind of a David Letterman-esque top 10 list. But we're really he's gonna try to convince people to change this from a cost savings exercise to more of a value maximizing exercise. So I'm gonna hand it over to Cary to walk us through his top 10 pieces of advice here.
Yeah, thanks, Tim. And I'll lead the discussion, and I know Annalisa and Ian and you also, Tim, can certainly jump in. But I think everyone's familiar with the old David Letterman show, The Late Show at Night, where he would start the show with his top 10. So I'm going to use his format a little bit. I've got 10 key considerations, and these are really just very practical points that I've learned from my kind of general experience and practice. Everyone will apply to you in slightly different ways, but hopefully this will be of value. And I'll break it down into kind of 3 general buckets. One are sort of very general overriding considerations, some points focused on managing cost, and then ways of extracting value and thinking about that. But the first thing that I always tend to think about is the trends. Follow the trends in the industry. And, we've talked about some of it. Right now is uncertainty. So whether it's uncertainty in the law or patent practice, or importantly in economics and maybe even market uncertainty that we're encountering now, it's nothing new, but maybe it's more magnified now than we've had in the past. And so understanding these trends and uncertainties, and then importantly, taking advantage of them, and finding a way of looking at your portfolio and understanding that, well, there is uncertainty about what the patentable subject matter may be under Alice considerations and other cases, or maybe there's still uncertainty in prosecuting patent applications depending on which examiner that you have, or maybe from one global jurisdiction to another. And so recognizing that there's uncertainty, instead of worrying about it, we always used to try to take advantage of it. And so follow that trend and say, well, given that there's uncertainty in the subject matter, we might file more patent applications or maintain more in a particular area of uncertainty, knowing that maybe we don't have enforceable claims, or it may be difficult to obtain significant claim coverage, but our competitors will take note of that. They'll see that we've filed in a certain area, and maybe we'll get lucky and have significant claim coverage, and maybe we won't. Internally, sometimes one of my colleagues used to call this a blitz and bluff type of strategy. I'm not sure I would articulate that too much, but it turned out to be an effective strategy to really indicate to our competitors that we may have the ability to obtain broad protection in some areas. And whether we did or not was irrelevant, because we would ultimately decide, depending on our strategies, which patents we would maintain and which that we weren't. So that was number 10. Number 9 is, we've talked about already, understanding the value of your portfolio. And Ian and Annalisa articulated this very well, that if you don't really have a good grasp of why you own patents, what they're for, is it defensive? Do you intend to enforce them, or perhaps license or sell them? Is it a kind of a short-term strategy for a rapidly changing area, or, as Ian knows, maybe a very long-term strategy that you need to build on? That if you don't understand why you own a patent, this is true for trademarks or even domain names as well, it'll be difficult to really manage them and manage them within a budget. I remember being challenged by the CFO of one of the companies I worked for. In fact, he was my next door neighbor. So I always remember coming home and I'd see him on the driveway, or maybe he'd be out mowing the lawn, and he'd always stop me, and he challenged me, and he'd say, "Why do we own all of these patents? Why are we investing so much money?" It took me a little while, but I finally developed my rhetoric, and I was able to go back and tell him precisely, this is why we own these patents, and this is what the objective is, and here's how we're able to manage cost and extract value. So hopefully none of you work next door or live next door to the CFO, but it was an interesting opportunity. So number 8.
Wait, Cary, I just sort of add on this, where you think about your portfolio, and often when there's large portfolios, there's a lot of patents that are on your books that are later in life that you might not be paying as much attention to because they're not being actively prosecuted. And with a large portfolio, there's often maybe a few cases here and there. They're noise day to day, but in a situation like this, it's an opportunity to really review those and cut back, and the aggregate, they can be significant. Whereas when one practitioner might look at it, could go, "Oh, that's just one case. We don't need to really look into that." But when you look at them all collectively, it can provide a lot of cost savings.
Yeah, I totally agree. It's a good point. So number 8, we've talked about a little bit already also, but it's develop a plan. And under the current circumstances, develop a pandemic plan and anticipate some of the challenges or crises that we have. So whether again, it's economic challenges, budget cuts, market uncertainty, maybe it could be opportunistic also. Maybe there's some pioneering new developments that you have that you need to be prepared to protect. But having a plan and being able to really be prepared to step into action and take actions. Part of it involves governance, and I know Annalisa mentioned having your patent review committees active and ready to quickly address situations. And I can give you the one example I remember is having a plan, and I probably didn't have a plan good enough. I got a call saying, "Cut your costs in half." So we were having some significant economic challenges, and no one asked me, and nobody tried to understand the value of the patent portfolio that we own, but they simply said, "Cut your costs in half." I did not have a plan for that, We did it, and it was a fire drill, and I know that there was a significant amount of value that was lost by doing it and doing it quickly. But I know if I had understood the value, if I was following the trends, and had a little bit of a plan and some process in place to address it, we would have certainly done a better job of handling that. So those are sort of general considerations, and let me pause for a second there. I don't know if anybody has anything else to add.
Yeah, I think following on that point, Cary, the idea of ranking and going through that exercise in sort of good times and say, this is what our portfolio is. So if you're ever in that situation, you can do it efficiently, do that cutback efficiently. Not that anyone wants to go in to do that, but it happens, as you mentioned.
Yep. And I like the idea of ranking because I think, as we all know, it's very, very difficult to determine a monetary value of any of the patent assets that you own. But if you can understand a ranking, or at least conceptually why you own them, we did it. We did a ranking, and every company does it slightly differently in terms of what's more important to them. But it was very, ultimately, I learned to be very efficient at doing that. Sorry, Ian, go ahead.
Yeah, I was going to say with the ranking, it's one challenge is not putting sort of specific patent types or claim types into a ranking and say sort of the strongest or the weakest, because it might differ from product to product. For some products, in my space, a patent directed to a composition of matter may be the strongest, and you give that the highest ranking, but we don't always have a composition of matter claim. We might just have a formulation or dosing. So in ideal situation, a formulation or dosing might be ranked lower, but in some instances it's ranked the highest for a particular product. So understanding why you're ranking them and having a record of that is important as well.
And the ranks change over time. So you need to follow Annalisa's process and use the patent review committees and then revisit it on a periodic basis. They'll obviously always change. Managing cost is important to everyone now. We seem to be under more and more pressure. Every time I think that this whole concept of cost management should be slowing down, it seems like there's just more and more pressure all the time to manage the cost. But as part of it, I learned to actually embrace budgets. They provided a good guideline to be able to operate under. I tried to not refer to my budget as a budget. I always thought it was more like guardrails or maybe guidelines, because in this field you never know what's going to happen, whether you've got some litigation in particular or maybe some innovation that requires significant patenting activity, et cetera. So it's very difficult to stay precisely within a budget, but if we make sure that our colleagues understand that, usually I found that they're okay with it. One of the ways that's becoming more and more prominent to be able to manage cost and manage your budget is outsourcing. Not only outsourcing to the Dilworth firm, who can handle your patent matters and preparation prosecution very efficiently, but also relying on outsourced service providers. So we're all more and more familiar with companies that manage patent annuity payments, patent filings, searches, maybe even some of the opinion work, global filings. What's becoming more and more popular is docketing services. There's a lot of companies and law firms that don't like doing that, and there's other service providers that are very efficient, cost-effective at doing it. Historically, we always used to think about there's some small company in India that would provide those services, some of them for us, and it's much more global now. There's resources in the US that can do it very efficiently and cost-effectively. But it improves efficiency, it reduces some of the administrative burden, and ultimately can reduce your cost. And I would encourage you to really explore those opportunities. There's some new ones. So, as we see some technology that's coming into our industry, it's kind of ironic that we're all helping others protect innovation, but sometimes we don't embrace innovation ourselves. One innovation is actually around drafting patent applications. There's a couple of companies that have software that will prepare I'll call it a rough draft of the patent application, and then they'll hand it back to you, and it helps streamline some of the preparation. And there's some groups that do that, and they're getting better and better at it and helping ultimately manage costs. So think about outsourcing. So I'm down to number 6, outside counsel. I always thought that selection of outside counsel matters in terms of managing costs. And there's a lot of very competent, very capable patent attorneys in this country right now, but there are not a lot that really align with what you're doing. So Annalisa and Ian and I had this conversation, and Tim, and the objective of making sure that your outside firm understands your technology, understands your goals and objectives, maybe understands your pandemic plan, and can be able to react and help you as much as possible. I know I could always negotiate a fee reduction with, whether it's a Dilworth firm or another, and I could get a few percentage off on their fee structure or whatever, which was always okay. But if I was closely aligned with them and working closely with them, I'd see a much more significant cost reduction in being able to work together, manage costs, and establish those really long-term trusting relationships. So outside counsel matters. Number 5, stratify work. This is something that I learned and trying to understand going back to value. And I know Ian and Annalisa, you've done this as well, but when you try to rank your patent properties, what you own, then I took the approach of saying, well, the top ones, my pioneering inventions, at least what I thought were the pioneering inventions and patents, I'm going to use the best law firm, best counsel, best process I can find. Then if I go to the bottom and I recognize, well, there's a few patent applications, it's the nephew of the CEO. And we did it. We've prepared them, we filed them. It was the right thing to do at the time. Maybe they don't add a lot of value. That's when I'm going to call upon a firm, maybe in a low-cost jurisdiction, that can help prepare a draft at a very low cost for me. So I would always look at the portfolio, understand the rankings and the values, stratify the work, and then decide how I'm going to manage the cost appropriately. That was always very helpful in trying to manage cost. And last one on the cost side, and then I'll pause again for a second, is fixed fees. And I know that we've all talked about this, these alternate fee arrangements that we've talked about for many years. How many of us are really implementing them? And how many of us still rely on firms that charge hourly rates? I endorse fixed fees, and I know that there's opportunities to work with firms, and the Dilworth firm is amazing and flexible, but there's fixed fees now that are what I call soup to nuts. So from the very beginning, even maybe handling searches and initial preparation of patent applications, right through to filing, foreign filing, prosecution, and grant around the world. They will quote you and adhere to a fixed fee for all of the services that are required to get you from filing to grant in numerous jurisdictions around the world. So it's kind of fixed fees on steroids. And I think it's something that we probably all should look at a little bit more closely. There's one group that called it prosecution, flat fee prosecution, but I think fixed fees are more and more advantageous in the way to go. So let me stop there, and then I've got 3 more. What do you think?
So yeah, so I mean, one thing I can definitely, managing cost, we review our outside counsel every so often. And, when I first mentioned that, I started an IP department here, so it was just me. So I had different needs than I do now that I have a team. And so I have different counsel that I will need. So I think really partnering and figuring out, what needs do you have and how that works. I know I shouldn't be mentioning this, but for sure, like if you can, if it makes sense to also have a balance where, if you bring some of the work in, then you'll be able to, manage costs that way. It doesn't make sense, obviously, to have all the work in, and it also doesn't make sense to have it all out. There's a balance, and the balance changes depending on, your company, and depending on your budget, and depending on the amount of IP that you're handling. But I agree. I think the partnering is key, because I have to say, being in-house, business comes to you continually and they want an answer immediately. And so if I need to be at the tip of my hands, be able to reach to my outside counsel and say, hey, what's the status, or where are we, or, update me on this. And, if the communication and the partnership's there, wonderful. If you send something out and you don't have that relationship, then you'll be sitting and waiting and you won't, it'll take some time. So I think, finding that outside counsel is important.
Yep.
Yeah. I follow up on the concept of fixed fees. I've seen fixed fees from both an in-house perspective and a law firm perspective, and I'm a strong advocate of them. I do think when you establish those, you have to sort of balance that with the partnership that you want with outside counsel, and ensure that while there might be fixed fees, that the outside counsel's enabled sufficiently to develop that partnership, so they're not worried about just sort of one-off costs, and it's sort of tight enough. So I do think that that's a burden that's both on the in-house counsel and outside counsel to have that conversation going forward.
Yeah, and I'll add to that too. In addition to telling everybody that we are happy to work with anybody on fixed fees, but when I did wear the in-house lawyer hat, fixed fees were a big part of what we did. In fact, more than half of every dollar that we paid to a law firm was via a pre-negotiated fixed fee. And, it wasn't as if we went out and just got a bunch of quotes on fixed fees and picked the least, the smallest one. It was more for the predictability of the spend.
Yeah.
Because in-house and companies, they want to know what the bills are going to look like, and it helps with planning and budgeting and all that. So yeah, I wholly agree with that, with the fixed fee model, because for a variety of reasons.
Yeah, it shouldn't be a race to the bottom. It should be an effort for predictability for both sides.
Agreed.
Yeah, I agree.
All good points, and I like Annalisa's point about outside versus inside, and how to balance the workload. I'd love to hear from our audience and see what they think. What's the appropriate balance? I know I struggled with it, and I ultimately ended up at about a 50-50 in terms of the prep and pros we would do internally versus externally, and then of course any litigation was essentially all external. So tough balance, but I would anticipate, if we did a survey right now, many would say that they're bringing work in-house in terms of the professional work, and the administrative work that I mentioned before, more and more is being outsourced. So there's kind of a little bit of a swing, and that'll change back, a few years from now, we'll probably go back the other way. But yeah. In the meantime, I'm going to jump ahead in the interest of time, because the other thing we talked about was increasing value, and so on the David Letterman list, we're down to we're down to number 3, right? But I always talk about transforming the IP department and the legal department into a profit center. So all of your corporations and your CFOs still think about legal as a cost center. And I would try to say and articulate to them that you're a profit center. So you are not going to be owning, you're not going to be filing, prosecuting, owning, and maybe enforcing patents unless they add value. It's theory anyway. And part of that is to define a strategy to monetize the patents. And I would tell you that I think every company, just like you're going to have a filing plan, you've got a budget, you're going to develop a pandemic plan maybe terms of managing the portfolio, I think every company should have a monetization plan. Some are obviously going to be much bigger than others, but thinking through and trying to articulate to your management how you might be able to extract value from the patents. So whether it's licensing, enforcing, etc., doing it. So I know, one of my experiences was working with a company that didn't do any licensing, no in licensing or out licensing of patents. They really rarely enforced. So it was really very, very, very large defensive patent portfolio. And I told them that I was going to make enough money to cover our patenting costs. So just give me a little bit of time and I would manage it and we would start licensing, and we did. So made a plan, we went out to the market, and within a couple of years, we generated enough royalty income. This was just through licensing, not enforcement, to offset patenting costs. And I can tell you they loved it. They were obviously really excited about that opportunity, but it took some time. It took a little bit of being like a monetization evangelist in the company a little bit, but reminding them that there's hidden value, or the end-of-life patents that Ian, and you may be dropping from the portfolio may be of value to somebody else, or your obsolete technology that you've developed, Annalisa, different engineering processes that have surpassed that innovation, that you may be able to license what I'll call second place technology and extract value from it. So there's a whole series of different opportunities that, at a minimum, you should consider and have a plan, and then ultimately exploit market opportunities. So especially in the situation that we're in right now, you look at what's happening in the US and around the world, exploiting opportunities. This is kind of shameful, but some companies are struggling right now. And there may be opportunities to either acquire or perhaps enforce some of our patents. I think I heard some statistics recently that patent litigation, it has increased this year. So notwithstanding uncertainties in the economy and in some markets, companies are going out and enforcing their patents, and which is great. I think could very well be the right thing to do, and it may be opportunistic to take advantage of this particular timing to do it right now. And it also reminds us that it's another way of extracting value in a lot of cases. But finally, in terms of increasing value, this last one maybe is the biggest one of all, because we're going to hand over the discussion to Dan, because finding ways of extracting value involves partnering with your tax department and your tax expert, which I've always tried to understand, but I'm thrilled that we have an expert here that can explain it to us in a lot more detail. So thanks to everybody. And Annalisa, Ian, any last thoughts or comments?
No, I think you covered it pretty thoroughly.
Excellent. Well, why don't we do just that and segue right into topic number 3? But before I do, I was remiss in mentioning at the outset that everybody who's listening in on the webinar does have a Q&A kind of button down at the bottom of your screen, which enables you to submit questions. We have one question already, and we'll be happy to address any questions or as many as we can at the end after this topic 3. So if you do have any questions, submit them and we will try to address them. All right, topic 3. Just to give a little bit of background here, this one almost comes full circle for me, because the reason I included this is because I saw Dan Gottfried speak at a different conference about the tax treatment of patent portfolios. And, it was like a light bulb went off in my head. I found it very interesting. It was a topic I hadn't really considered or didn't think of as a top priority, but over years working as an in-house attorney, it became more and more clear about how important this is and what steps you can take to take advantage of the minimize the amount of taxes you pay, but also set up processes to track your expenses efficiently so that you can maximize the tax treatment of your portfolio and your costs. So without further ado, I'll kick it over to Dan, and perhaps it's a good idea to start with the basics. Can you help us out with some general tax treatment for patent-related expenses?
Yeah, sure. Thanks, Tim. And by the way, Cary, if you thought IP was fun, wait till you see how fun taxes is. General patent-related expenses. So, companies paying for costs of patent prosecution, things like that. The general rule when you're creating a new asset is that you have to capitalize those costs and that they're not deductible. But there are some special rules for patents and some other IP. Specifically, the section of the code that talks about research and experimental expenses and gives taxpayers the opportunity to deduct immediately research and experimental expenses or amortize them over 5 years. It's sort of up to the taxpayer. And in a number of circumstances, you have to really consider what are you doing and does it qualify as research and experimental. Things like quality control and advertising and stuff like that don't qualify. The good news for patents, frankly, is that a regulation just says, any expenses relating to patents or creating patentable things qualifies as research and experimental expenses. I know a lot of companies will try to track, what they're spending on their patents and even what they're spending on R&D leading up to patents, because it does help to corroborate this expense. These costs would include, patentable technology, legal fees, things like that.
Is this the only treatment available?
So no. So the other treatment that taxpayers sometimes go for is a tax credit. A tax credit, so a tax deduction, just sort of level set for everyone. A tax deduction reduces your taxable income. Then you multiply your taxable income times the tax rate, and that equals the amount of tax you actually pay. So a tax credit reduces the amount of tax you actually pay. So it's basically a dollar for dollar reduction of taxes. Depending on the taxpayer's individual characteristics, they may prefer a deduction or they may prefer a credit. It sort of depends on some of their situation. In particular, what states they do business in, because if you take a credit, you sort of lose the state tax deduction. So credits are again pretty complicated, but there is a special credit for R&D expenses the calculations are complicated, but we can just say for today, it gives you 20% of your R&D expenses, you can take as a credit.
Okay. Now, this seems to like these all assume a company's paying taxes. I know we've got some folks from startups that are part of this webinar, and other companies that have expenses that exceed the revenue, and they might not even pay taxes. Yeah, no, it's a good point. And so there's a couple things to think about here. One is that the deductions and the credits typically can be carried forward. So deductions for a taxpayer that doesn't have taxable income would lead to a net operating loss that they could carry forward. Credits themselves are typically, you can carry them forward. But there are also some opportunities to turn the credits into cash. For example, a number of states have programs that allow state level R&D tax credits to be turned into cash. Connecticut, for example, for small taxpayers, I think the test is $70 million revenue or less. They can cash in their R&D tax credits at 65 cents on the dollar, up to about $1.5 million. So some states have programs like that. Now, of course, that only applies to the state tax credits. It doesn't apply to the federal. Also, if for global enterprises, a lot of foreign countries have programs that are similar, providing cash refunds for unused tax credits. The list is really long, but the UK, France, Canada, Australia, there's a lot of countries that provide a tax refund for unused tax credits. All right. So speaking of international, I hear a lot of corporate structures for international companies.
Yeah, and it's sort of one of my favorite phone calls and one of my least favorite phone calls, because we'll get these phone calls that taxpayer says, I hear if I just put all my IP in the Netherlands, I can do this and that and never pay taxes again anywhere. Isn't that what Apple does? And there's a really long answer and there's sort of a shorter answer. I guess it's important for companies to focus on value accretion. Particularly if you're starting a company and you're going to create products and services that are useful in many countries, you want to sort of think strategically about where the value should reside. Obviously, IP is nascent when you start it, right? When you create IP, it typically has no value. And then between what you do on the legal side to protect it and what you do on the R&D side to develop it, eventually someday, hopefully, it has a lot of value. There is an awful lot of planning that can be done between those 2 points, between the point of the idea and the point of the commercialized product. So number one, we do like to focus on where should the value accrete. What entities should own the IP, and where are they located. And it's very customized based on what the company's plans are, where the owners reside, and where the activities are taking place. The other thing I should mention is in the 2017 Tax Cuts and Jobs Act, this was the huge tax reform bill a few years ago, they created a new sort of type of offshore tax that they call GILTI, global low taxed income. And what they're trying to get at is income derived from IP offshore. So they were basically targeting large US tech companies that were keeping all their profits offshore. And under this new GILTI regime, any returns that a company earns offshore in excess of 10% of the value of its depreciable tangible property, so not the IP value, but the tangible property value, whatever you earn in excess of 10% of that value is GILTI. It's tainted income, so to speak, and you end up with a 10.5% minimum US tax on that income. So because of this new tax rule, a lot of the strategies companies were using in the past to try to keep their value offshore don't work as well for US companies, and also actually frankly make some different choice of entities for US companies. We find ourselves using US corporations much more for startups these days than in the past when we maybe would use US LLCs. So those are some thoughts for international companies. I would also add that it's very important if you're an international company to think about joint development agreements. Which entities are developing the IP versus which entities own the IP, and there's a lot of strategies around how to effectively allow different entities in a corporate structure to use the IP that they need to use and pay appropriate royalties to their affiliates. I guess last but not least in my list for kind of international thoughts is that there is this global push against tax planning. It's really this global push towards business substance and seeking to tax companies where their consumers reside and where their services and products are being used. And it's a new push, but we talk these days so much about substance. And so as our listeners are thinking about building their international portfolios, and undoubtedly anybody in international business gets lots of great advice at cocktail parties to do various things of various degrees of legality. But just about anything that involves forming a company that's going to live in some lawyer's desk in a foreign country doesn't really work anymore. To the extent that it used to work a little bit, it really doesn't really work anymore. So we have to make sure that we have good substance and business behind these international structures. Great.
And so companies sometimes have patents that can be valuable but of limited use to the particular company. Is any tax planning available in that situation?
Yeah, that's a good one. Companies and even individuals, in some cases inventors and things, used to be in the practice of donating patents or donating IP to charities, and it's something that people still talk a lot about, but it's actually been pretty well shut off by law you know, people would take sort of aggressively high valuations of their IP and they'd give them to a charity and then take a tax deduction for that. In some cases, the charity would even, you know, license it back to them or agree. You know, so in some cases, the charities would agree that, you know, we won't license it to anybody ever. And so companies could use this as like a blocking tool. You know, I can block anyone else from using this IP and also take a charitable deduction. But anyway, you know, since around 2004, it's been pretty much outlawed because the amount of the tax deduction, if you make a donation of a patent to charity, is the lesser of the fair market value or your tax basis. Your tax basis is sort of all the costs you incur in creating or purchasing the patent. And as we talked about a few minutes ago, most of those expenses ought to be deductible along the way. So the only times that we sort of see this used these days is patents that are acquired by purchase, so that they have a higher tax basis, or patents actually do have value and are generating royalties, and there's a true desire to kind of give the charity a royalty stream. But in terms of you know, culling the weak patents and then packaging them up into like a valuable tax deduction, those days are pretty much over.
So I'm basically going to take Cary's advice, and if I have tax questions, I'm just going to call you. but I guess circling back to the basics, and you know, maybe Ian, Cary, and Annalisa might have quite a bit to add here. For the startups, the RD&E people, the folks running you know, a small company out there, what advice is there for, you know, and maybe this is more accounting than anything, but what's the best way to track and characterize all your expenses in real time so that, you know, you're getting all these benefits that you should from your expenses without, you know, kind of with minimizing the amount of work involved?
Yeah, I mean, I certainly defer to the other panelists who you know, live by budgets more than me, but certainly talking to you know, real good accounting help in the beginning to set up your books so that you're tracking, you know, these expenses in real time. Yeah, I don't know if I have thoughts.
Annalisa, it looks like you're
Yeah, this has been like, it's an interesting challenge because when they come to you at the end and say, hey, we want to get all the numbers and all the information, it's a real hassle and difficult to gather all that with all the, you know. So I know that there are programs, kind of like Cary says, outsourcing. So I know that there's programs that the engineering group can use when they're developing IP and things that they can kind of track some of the work and cost and time that goes into developing some of that.
Sure. Yeah, and I had something of a nightmare experience years ago. Again, when I'm back in my in-house days, where we were handed, you know, thousands of invoices that were 5 to 10 years old. But you know, they were working on an audit, and you know, basically given a stack of paper and a highlighter, and we went through them line by line trying to capture expenses that hadn't been grabbed. And I know at the end of that, I really wanted to make sure I never had to do it again. So we did spend some time with our tax department, and you know, we definitely, you know, educated them on what we do, and they educated us a little bit on, you know, what they were looking for as well. And you know, I think the lesson is that, you know, the patent team or RD&E team, you have to have these open conversations with your tax and your accountants, your tax team and your accountants to make sure that you are doing everything correctly. You've got the right setup, and then you've got the right system for tracking it as well.
Yeah, the coordination is really key, and I think these different units, you know, need to really see each other as you know, complementary to one another. And I think if the tax folks obviously can help the IP folks, you know, unlock value and kind of bring more money to the company, and certainly vice versa. So kind of viewing it that way, Tim, as you described, but just closer collaboration makes a ton of sense.
I mean, even in the, and this, I know this is a little bit off topic, but the licensing that Cary's talking about, I mean, really, you know, when that stuff's, when we start working licensing, I really team up with the tax team too, to kind of figure out what structure makes sense, especially if it's overseas and it's not all US oriented. So trying to figure out, okay, well, you think you're getting this percent, but you know, what's on top of it. So it's, you know, you could definitely have to work closely with the tax team. It is frustrating when everything's a little gray and not black and white, but that's what they say about everything, even, you know, anything in IP and law, they're always like, you know, then R&D, they want black and white, and it never really is. So, but yeah.
Excellent. Excellent. Well, we've received one question, so I'm going to, I have a partial answer, but I'll invite others to also address it. It's for small, the question is, for small startups, does anyone have experience with grants or loans under this current circumstance? And as well as what do you do for funding for clients that don't have a big portfolio to cut, but are looking for efficient ways to select what to file? You know, I don't know what other folks have had as an experience, but mine, you know, my N equals number is not huge, but it's, you know, it's not zero either, that the startups that I've dealt with who are reaching out, funding is available, that this VC and private equity out there, they still are investing in companies very actively, and that it's not, you know, during this current crisis that hasn't dried up. As far as really practical advice, I don't know if the questioner is here from Connecticut, but I know most states have some sort of either governmental or quasi-governmental group. In Connecticut, we have Connecticut Innovations are just one option where they facilitate grants, loans, they have investment funds, or they also help to network. In addition, you know, I know I've worked with some clients to help them get in touch with even just people in my own network who are in this business. So I guess my experience is that it's still very possible that funding is still out there at the current time. You know, I don't know if it's harder or easier, but I do know that it hasn't dried up. I don't know if anybody else has something to add there.
You know, Tim, I'll add one thing, and I don't want to state the obvious, but you know, when you're looking for funding, a lot of these organizations often do focus on patents. So they're going to look closely at IP portfolio, whether it's an existing or maybe a plan. So again, having a plan to develop a robust patent portfolio, that's one of the key value drivers that they're going to consider when they're granting funding. I think that's more and more the case. So it's another reminder to develop a plan, develop your portfolio, understand the value, talk to Dan Gottfried to make sure that you've got the optimal tax considerations, et cetera. But yeah.
Yeah, and then just to address that second part, you know, what if you don't have a big portfolio, but you're looking for efficient ways to select what to file? You know, that's really a super case by case, you know, basis type of answer. And the only advice I can say is, you know, maybe Dan can't help you, but your patent attorney can. So I would say definitely reach out to your counsel and work with him or her to figure out what that best strategy is. You know, that's the best advice I have.
Yeah, there's one other funding source just just to kind of complete the circle. I've seen a number of companies go through rounds of federal governmental funding, you know, usually because they have something that's particularly interesting in the healthcare or national defense spaces. But there is a lot of federal money, and there's a number of really successful companies that started up with even tens of millions of dollars through multiple rounds of federal grants. So depending on what you're working on, that might be another angle to look for.
Great.
I won't speak to the funding part of that, but the sort of what's in the portfolio and what to cut. As someone that's worked in large companies and has evaluated a significant number of small company portfolios, I would say that it's quality over quantity in terms of patent filings, and that groups that are funding are not often concerned with how many patents are in the portfolio, but what is this patent, is this IP strong, does it cover the product or the space you're developing in? So think about that, work with your outside counsel and understand, so what are the drivers of the technology we're going forward with, and identify if possible the IP that you might have filed on early on that doesn't directly apply to the assets that you're trying to sort of fund and develop.
Excellent, excellent. Well, that generally brings us to the end of this webinar. We ran a few minutes over, so I thank the audience for hanging in there. I'd like to thank everybody who joined online today, and then I would really like to extend a sincere thank you to everyone on the panel. I thoroughly enjoyed preparing for this with you, and I can't thank you enough for all the time that you gave. This was great, so sincere thank you. And with that, I think we will wrap this up.
Thank you, Tim. Thanks, everyone.
Great.